Good morning. My name is Joel Green. I'll be here with Curtis Woods. Curtis is the general manager of Dignity Memorial. He's also part of the executive committee board and a board member of the Santa Clarita Valley Chamber of Commerce and member, most importantly, of Santa Clarita Senior Resource Alliance. The Santa Clarita Valley Resource Alliance is a group of professionals, in case you don't know, that deal with all the issues as we age. Some of the specialties in the group is Curtis being part of Dignity Memorial, so mortuary issues. I'm with Home Instead Senior Care. We deal with in-home care for seniors. We have part of our group is Mary Demkowski and Margie Weiss of Oakmont Senior Living. Another member of our group is Patrice Rifkind. Patrice is the director of Audiology Associates. Other members include Dr. Jill Brink, the only gerontologist in Santa Clarita with aging interventions. Another member of our group is Lions Pharmacy. We have Girl Friday Errand Service. We have Janelle Percy with Edward Jones Investments. So there's a wide variety of people here to help aging in place and also to help seniors and adult children plan for the future. On that note, part of what we're doing today and what we're doing in the coming weeks is our series on aging in place through the Santa Clarita Valley Senior Alliance. And it's part of making your own decisions. And we're going to take a break, and we'll be back with Gina McDonald. You're listening to KHTS, your hometown station. Senior Moments will be back in 3 minutes. Good morning, I'm Joel Green. I'll be here along with Curtis Woods. The subject today is Issues in Aging, Handling Your Legal Affairs. Our guest today is Gina McDonald. Gina is an estate planning and elder law attorney with extensive experience in trust creation and administration, probate, conservatorships, guardianships, Medi-Cal, and elder law issues. Gina has over 40 years' experience in the legal field and has been a practicing attorney for over 25 years. She is a member of the Santa Clarita Valley Bar Association and the San Fernando Valley Bar Association. Gina, good morning.
Good morning, Joel.
Okay, so we probably should start. Let's kind of delve into this. So a family member comes to your office for legal advice. They may have parents, they may have grandparents. How do you begin this process with them?
Well, normally what's going to happen is someone's going to call my office. That helps me to define who the client is going to be.
Is that important?
For an attorney, it's very important because there's an attorney-client privilege when you are being the attorney for a client. So if the client is a child, then if the child is coming to see me for issues that the child is reacting to, what's happening with the parent, the child is my client. If the client is the elder, believe it or not, the elder is calling my office. And normally they're leaving a message and I give them a telephone call. And they're telling me a lot of times what they're trying to do is to put initially their affairs in order. When we're talking about elderly individuals and putting affairs in order, a lot of times that's going to be doing some type of estate plan.
And what is, when you say estate plan, to me that immediately brings to mind an estate. Well, I'm not a rich person. So what's in, I have a little of this and a little of that, but what's an estate?
One of the things that I always hear from clients is, I don't have much. I only have my house. I have a few bank accounts. And I know it doesn't seem like you have much, but in California, just your home is a very large value. So normally when people are coming to see me, what they're doing is they're wanting to usually make sure that their home is protected, that they can avoid what's called a probate process, because when you look at what the California statutory fees are for attorneys and for executors in doing those legal affairs and going through a court system, it can be very expensive. And if you're trying to maximize what you can leave for the people that are left behind and make it easier for them to get through the process without having to go to court, there's a lot of people that want to do that.
When you say your client and defining your client, I was always under the, well, maybe not always, but I was under the impression that your client is the one who pays your bill.
Oh, unfortunately, no. As I said, there's an attorney-client privilege. What I have to explain to clients when they come into my office with additional members of the family, in the waiting room, I'm speaking to them about the fact that they are my client, that anything that is said in that room, I can't disclose to anyone else. They are the holder of that attorney-client privilege. So they can waive the attorney-client privilege to allow additional people to be present at the meeting. Then I normally ask them, do you want to waive the attorney-client privilege? And I tell them a consequence of that is that if you think that people might not be too happy about what you're doing, that you may want to consider not waiving the attorney-client privilege, or if all of the children are not here at the meeting, or if you're looking at excluding a child or anything like that, you may not want to have everybody else at the meeting and waive attorney-client privilege, because if someone's not happy and they want to sue the estate, they can, in depositions or anything else, let's say that they subpoena me and they say, what was said in that meeting? And I say, attorney-client privilege. A smart attorney will then ask me the next question. Was anybody else present at the meeting? I have to truthfully tell them. Then they can subpoena those individuals to find out what was said at the meeting. So I try and explain to clients that there's pros and cons for having additional people in on the meeting, and let them make the choice.
So if you have an attorney-client privilege with me,
yes,
and there are other people present,
yes,
that attorney-client privilege might not extend
only extends to the client.
Ah.
Only extends to the client. And so that's why so much of my job before we get down to doing anything is explaining consequences. The two biggest issues when people come to see me before we do anything is, number one, who do you trust? And then number two, with the actions you're taking, let's talk about the consequences. Because as we age, our pool of individuals who are willing to take care of us, handle our assets and everything else dwindles. And so these are issues that you have to look at before you do anything. And that's one of the reasons, Joel, when people come to see me, we make an appointment for them. They've already spoken to me. I've gotten an idea of what the issue is. And then we send out an appointment letter with questionnaires. And in that letter, we're asking them to bring documents. We're asking them to bring things with them to the meeting, because we want to make that meeting worthwhile.
What's in the questionnaire? Of where do you live, age, height, telephone number, what else?
Some of that, but it's also the names and dates of the children. If this is a blended marriage, then I need to know the children of both spouses. I need to know if there's any children of the marriage. Do we have any deceased children that have issue? That would be like grandchildren. We then have to look at also, believe it or not, burial instructions. I was hoping that the individual would be here today, because I am a huge proponent of people at least letting their beneficiaries, or the people that are left behind, know whether they want to be cremated or they want to be buried. And I normally, when we're talking, I'll say, do you want to be a crispy critter, or do you want to be buried? And normally it helps to diffuse the stress that everybody's under when they see me.
So somebody comes in A family comes in, and let's say the family is a husband and wife, and maybe a parent or two parents of either the husband or the wife, and maybe the husband and the wife's children. So essentially, we have 5 or 6 people present.
Well,
How do you start that process?
first of all, that's not usually the norm.
Oh, okay. What is the norm?
The
Let's
norm
start there.
is usually that the husband and wife or the surviving spouse will come in and see me.
Okay.
The norm-
Would this person be adult children, or would they be essentially the parents of adult children?
Again, that depends.
Okay.
If they're new to planning, they're usually going to be the children of adult children,
Okay.
of the elder.
Okay.
If they already have a plan in place and now they need to tweak it or change it or do something to it or find out the consequences of the document they signed,
Okay.
it'll be the elder or the elders coming in to see me and saying, "What did I sign, Gina? What does this say?" Because I'll say to clients, you're going to show me a document that's going to have a whole bunch of legal mumbo jumbo and tax mumbo jumbo. And I know that you're not going to understand that. For a lot of people, the elders, they did their estate plan quite a while ago when the exemption for estate taxes was $600,000. It's over $5.4 million per person now. So there was a lot of different types of planning that people did when you could only exempt $600,000 each from a death tax. Well, maybe you don't want to do the same thing anymore now that you can exempt over $5.4 million going up.
Now, to me, being a person of moderate means,
Define for me moderate.
I'm going to.
Okay.
600,000 is a big number.
Yeah.
5 million plus is an even bigger number. For most people, I would venture a guess, their estate probably does not rival those figures.
I would say now that our exemption's at 5.4 million and up, you're correct. You're correct. You can double the exemption, and there's ways to do that.
And when we come back, we're going to talk further with Gina McDonald. You're listening to Senior Moments, Issues in Aging, Handling Your Legal Affairs on KHTS AM 1220, your hometown station.